Hi, my name is Sheila. Welcome. We are back to talking about Todd and Julie Chrisley of Chrisley's Knows Best, the reality TV show that I think has been canceled and is no more. They were convicted of bank fraud, wire fraud, tax evasion, conspiracy, all of these things. And now they are scheduled to report to prison January 17th. And of course, they are filing an appeal. The question is, can they stay home while this appeal is, going through the motions, or are they going to have to carry this out, serve this time in prison while they're, going through the appeals process? Well, a judge just announced that, guess what?
Yeah.
You guys are not going to be able to stay at home. You're going to be heading to prison now. But let's take a look at the government's memo, because the government submitted a memo saying, no, 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 we do not agree with this bond. And here are our reasons why. Now, technically, there are going to be a couple of reasons, but we're going to backtrack first for those of you who may be not up to speed with everything that has been going on. So here is the government's response in opposition to defendants' motion for bond pending appeal. And this is what the government submitted. So, of course, you have the background information here. Let me just touch on that for a second, and then I'm going to scoot through to the end. After a 3-week trial, a jury convicted defendants Todd Chrisley and Julie Chrisley of multiple charges, including bank and wire fraud and separate tax charges. The Chrisleys filed joint motions for a new trial and for judgment of acquittal, which the court denied. In November 2022, the court sentenced Todd Chrisley to a below guideline sentence of 144 months imprisonment and Julie Chrisley to a below guideline sentence of 84 months imprisonment. The court has permitted the Chrisleys to remain on bond until they are required to report to the Bureau of Prisons to begin serving their sentences on January 17, 2023. As I mentioned before. On December 7, 2022, the Chrisleys filed separate motions for bond pending appeal. They subsequently filed a joint motion for a prompt ruling on their respective motions and requested to delay their report date. This court denied their motion to delay their report date, but ordered the United States to file a response to their pending bond motions by January 5th. The court set a hearing on the bond motions for January 10th, which is today, right now. Both motions argue that this court's rulings deny their motion for a new trial based on alleged Brady and however you say that violations, and denying their late filed motion to suppress evidence. Julie Chrisley separately offers that the court's allegedly improper loss calculation at sentencing merits her release pending appeal. Okay, so all that aside, what they're basically saying is, hey, we're the government. You told us to file something stating our concerns about them, securing bond on appeal. And we're going to say, no, we don't agree to that. So first of all, they're going over the legal standard. This is the standard for bond pending appeal is exacting. And there are two parts to it. The first part has to do with this danger or flee. Okay, so it says, A, by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. And then B, that the appeal is not for the purpose of delay and raises a substantial question of law or fact likely to result in, and you see the items that are listed there, those 4 items. Okay, so I'm going to skip B because I want to focus on why the government is saying, that they don't meet the standard where they don't pose a danger to the safety of another person or the community. So the government spends a lot of time talking about B, and we actually have to scroll through this 19-page memo, get to page 16, I think is where the government finally goes back to this section where it says the Chrisleys cannot demonstrate that they are not a danger to the community. So it says here's the burden, okay? Accordingly, even if they could show that their appeals present a substantial question likely to result in the reversal of their convictions, which they have not, they cannot carry their other burden of establishing by clear and convincing evidence that they are not a danger to another person or the community. The United States briefly summarizes their past obstructive conduct, much of which occurred while they were on bond. So remember, they were out while the trial was going on. It's not like they were serving time then. They had been released. And I want to go down this list because I do think these four factors are very important. I think that's why the government chose to include them. This first one says the Chrisleys caused a sham, backdated corporate resolution to be transmitted to the grand jury investigating them. So it's sort of like, you started out on the wrong foot. Here you are, you're facing these charges, and you continue to go down this path of obstructive behavior. Then the second one, both Chrisleys, and this is actually both for the first three of these, both Chrisleys suborned the perjury of their former employee, Donna Cash, who repeatedly, okay, falsely testified at trial and directly contradicted a recorded statement she had given to the defense team. So, it's sort of like you are obstructing the process, the justice process that's supposed to take place. Number three, okay, so those first two have to do more with the process. These last two I want to talk about because I think they're so personal in nature. The third one says both Chrisleys suborned the perjury of Todd's mother, Faye Chrisley, who falsely testified about a key incident at a Bank of America branch. Now, let me just stop here for a second. I mean, at this point, it's sort of like, okay, you did some false documents. Okay, there was this thing with the employee. But now you're in the position where you're willing to throw Mama Chrisley's life to the gutter also. Like, you won't stop. Is there anyone you won't throw under the bus or willing to put them in legal jeopardy to make sure you're saving yourself? I think that's what the government is sort of saying here. That's their position. It's sort of like, okay, yeah, they did these other things that were more procedurally, but let's talk about what they're even willing to do to their family. And remember, it says to another person or community. And so you got the family. If they're willing to like I said, throw Mama Chrisley under the bus to get what they want, I think the government is then saying, how can you expect them to not be willing to pose the same sort of danger to other people or to the community? Okay, so I think that's I think that's a real reason why they included that one in here. Who throws Mama Chrisley under the bus? I don't know. All right, let's pop back over to the last one. And the last one is more of the same because it's another personal one where it says Todd, and this is not both Chrisleys, it says Todd Chrisley threatened, intimidated, and unlawfully influenced his daughter, Lindsay Chrisley, with the threatened release of a supposed sex tape of her. Okay, so, it's always interesting that we have these sex tapes that show up, but, this relationship with his daughter, it just got to the point where, of course, his daughter, really didn't want to have a whole lot to do with him. So again, now think about this. The standard here is that you have to be able to show with clear and convincing evidence that you are not, okay, that you're not this person who might pose a danger to another person or the community. Here, we've already given one instance of Mama Chrisley where, you got her to do some things regarding this, this key incident at Bank of America. And now you have your own daughter, okay, daughter Chrisley Lindsay, and you're intimidating her with a tape that you supposedly have this tape that you might release or might do something with. You are willing to do that to your own daughter. Okay, so your own mom, your own daughter don't mean enough to you, is what the government is saying. So why would we expect you not to pose a danger to people you don't even know, the community at large? And that is what the government is saying. And then they go on to say, let me scroll down a little bit further here. The government goes on to say the Chrisleys' obstructive conduct did not end there. Todd Chrisley repeatedly lied under oath during proceedings pending before Judge Batten about issues pertinent to the case, including lying about his role in Seven Seas Productions and not knowing where Seven Seas Productions banked. Just this past week, two unrelated individuals reached out. I think this those be two when there is missing, reached out to the court with claims that the Chrisleys have continued to commit crimes while on bond. Now, okay, these are claims. They're including them, but these are claims. One individual emailed the court explaining that the Chrisleys have had taken money from consumers but failed to deliver a subscription box as promised. And Amy Doherty Hines, who is engaged in a lawsuit against Todd Chrisley, emailed the court that she has been victimized by Mr. Chrisley since March 2020, and the ability for him to remain out on bond with access to his large fan base, who also have harassed me, his social media, and his podcast will further exacerbate his already inflated sense of entitlement and allow him to continue to victimize me and others. Okay, so this has become an issue. There's my phone that I neglected to turn off this time around. So here's the thing. A lot of times when you have people who are celebrities or who have a very public image, then they have a very large fan base. And if you start to say that you're dissatisfied with something or you don't like something, sometimes your fan base will reach out to those other people, even if you haven't directed them to, just because you have said some things. In this case, it's not clear because she didn't directly they didn't directly include instances where it says he said, oh, say something to her on social media. There wasn't all of this in there. But he has, if I recall, 2.3 million Instagram followers. And let me see if I can pull that back up, because I had just looked at this the other day and I thought that that's how many it was. But of course, my memory is bad at this point. So I have to pull it up and make sure what it says. And yes, he has 2,873 posts. He is following 231 people, and he has 2.3 million followers. So imagine how many people might respond if he said he was upset with a certain person and felt like this person was maybe harassing him or saying bad things about him. So this person is very upset about this. Oh, let me go to the last part here. And I think that pretty much sums up the government's statement on that. But that's why the government is saying, hey, they cannot show by clear and convincing evidence that they're not a danger to people. Because look at what they're already doing. Look at what they did to Mama Chrisley. Look at what they did to Lindsay Chrisley. And then we have this other person coming in and talking also. And so you have their conclusion there. For the foregoing reasons, the United States respectfully requests that the court deny the Chrisleys' motions for an appellate bond. And remember, there were the other pieces there too that the government had to argue, but I really just wanted to focus on this whole thing about them being in danger and why the government felt they were a danger and why they included certain aspects of what had happened, and mainly those ones focusing on family. If you will do it to family, some people feel like you will do it to just about anybody. So hope that gives you a little bit more insight into where the government was coming from. If it does, definitely give the video a thumbs up. Don't forget to subscribe, and peace.